Harding Marital and Family Trust, case number 2020-0808. I think first of all, we'll invite council to make an initial appearance and then talk a little bit about the way we'll do the time today.
Yes, Your Honor. David Lambert from Howard Lewis and Peterson, our office is in Provo. And Chris Grolick has not previously made an appearance in this case. But Mr. Slaw, who's on the briefs, happens to be in the Philippines being associate counsel for the church in that area. So not available. And Mr. Grolick is here to assist.
Thank you.
Good morning. Russell Walker appearing on behalf of Rick Taylor, appellant. And I think maybe it's premature, but I think we'll be dividing our time about 5 minutes each to begin with and reserving 5 minutes for rebuttal.
Thank you, and we'll address that a little further here as we go.
Yes, Jared Moss on behalf of Robert Harding.
Thank you.
Good morning, Stephen Bergman on behalf of Jill Kendall.
Thank you. We recognize in this initial matter that there are a lot of issues, and we understand that you have reserved 5 minutes for rebuttal and anticipate dividing your time. We anticipate having plenty of questions, and as long as the bench continues to have questions, we don't want you to be overly concerned about the time, and we'll help manage the clock that way. As you come to the podium, if you'll again state your name at the podium, that'll help our oral or our recorded record be clear for those who may be listening now or later on that. If there aren't additional questions, we'll then go ahead and proceed.
Members of the court, I'm David Lambert. I represent the estate of Margie Harding. And what I would like to begin with is that the trial of this case was limited to damages by court order, and that order was not ever modified. Neither the liability of the estate nor the liability of Mr. Taylor was tried. The order of June the 27th of 2017 granting partial summary judgment decided the only liability issue, which was that Mr. Taylor was liable, and the only issues were going to be regarding damages. And the court listed 5 issues of fact that were going to be tried.
Yeah, I wonder if that order is narrower than that, and I'd like your thoughts. The real, the court says he finds, and that's a pet peeve of mine, that courts find on summary judgment, and that's not a thing. Courts are making legal conclusions from undisputed facts. But at any rate, one of the legal conclusions that the court made was, and this is really the big one, was based on Rick Taylor's admissions and the evidence before the court, Rick Taylor made unlawful distributions of principal from the marital trust. Nobody ever decided on summary judgment whether Rick Taylor made unlawful distributions from the family side of things, right? I mean, in other words, nobody went through the whole analysis of, did Mr. Taylor look at Margene's needs? Did Mr. Taylor look at Margene's other assets and thereby exercise his discretion to make distributions from the family side? That didn't seem like it got decided at summary judgment. All that got decided on summary judgment was that there were unlawful distributions from the marital side. Am I reading that wrong?
I could be wrong, but I thought all the distributions were from the marital trust.
Okay. And so in your mind, that did resolve everything?
Yes.
With regard to the legality of the distributions or the lawfulness of the distributions?
Yes, and of course, that wasn't our issue for the estate, because the only issue, if you look at those A through E, those 5 issues that the judge preserved for trial, only one of them pertained to the estate, and that was in regard to the promissory note. And so the only thing that was to be tried was what interest was due on the promissory note that Mr. Harding and Ms. Kendall had
Yeah, that was
made.
on your petition. The summary judgment motion went to the other petition, right?
It went to both, as I understood it. If you look at the order, I believe that Both were under consideration. And the fact is that because there had been no pleading against the estate of any cause of action or any theory of recovery against the estate, it just wasn't an issue. And I would like to particularly refer to the motion to bifurcate that was made shortly after the partial summary judgment was entered. And I think it's short and it's worth quoting. In the motion to bifurcate, Mr. Harding stated, "The issues in the marital trust matter and estate matter are clearly separable. The estate matter requires fact witnesses and expert opinion on issues dealing with only one issue, the accrued interest on the 2005 promissory note. The marital trust matter deals with damages to be assessed against Rick Taylor only. These issues and expert opinions do not overlap." And so going into this trial, it was clear that liability on the part of the estate was not an issue. And subsequent events confirmed that. The court, it was a bench trial, and the court asked for findings. And so each party submitted proposed findings. And in Harding's proposed findings, they did not ask for judgment against the estate, with the caveat that they asked that whatever share of the estate was due to Rick Taylor, that they asked for a constructive trust to be imposed on his share of the estate only. And in the ruling, which is, in the findings of fact that the court issued, which is addendum A to our brief, it's 77 pages long. It doesn't impose any judgment against the estate, none. And it only even has, it discusses the promissory note, of course, but aside from that, it really doesn't deal with any
You're right, but the
issue.
court had told you guys about 3 weeks earlier that it was going to impose liability against the estate, right? This was sort of, these findings were issued at a sort of weird time in the case where there were still some issues open, right?
I would say not. I would disagree with that, and here's why. If you look at addendum B, which is the ruling on it, he says in the preamble to his ruling that he had asked the parties to brief the issue of the liability
Yeah, I
of
mean,
the estate.
I get that, but I mean, I yesterday read the transcript of the November 21st hearing, and he says it straight out. I'm going to impose liability on the estate, and then you guys objected. I think it was Mr. Slaw, and said, I don't want to argue with your ruling right now, but we'd like a chance to brief this. And that's how the briefing got going. He was clearly in his mind going to do this. Question is why and how, right? That's what you're here to tell us about.
Right, and that's what I'm saying is there was no evidence presented at trial. There was no pleading to alert us as to what cause of action might be involved against the estate at trial. There just simply was nothing.
Well, let's talk about the theories that are out there that might support this, right? It seems
Okay.
like that the red brief, Mr. Moss is going to, what he's said in his brief is some sort of agency theory.
Right.
But I don't see that in the court's ruling on this. And it doesn't look like the court went through apparent authority and actual authority in the Burdick case and all the things we would expect the court to do if it was making some sort of agency determination. I take it you're going to agree with what I just said, right?
Yes.
Okay.
Yes.
So there's agency theory out there, that's the theory that's being defended now. Then we have this theory that the court actually relied on, which is just kind of this thing of, he was everywhere, everything everywhere all at once.
Yes.
And therefore liability attaches. And I guess I wonder what you make of that theory. It doesn't seem to be being robustly defended by Red. They seem to have planted their flag in agency now, but that's what the district court thought. What do you make of that?
I couldn't figure out where the judge came up with that. It came completely out of the blue. It wasn't part of our trial. We didn't present any evidence at trial on the part of the estate, except as to the interest rate. We established the promissory note. We called an expert to talk about the interest rate. That was the limit of what we did. We did not participate in any liability issue except
Right,
the
but
liability of
The underlying facts the underlying facts the court relied on seem all to be true, right? Mr. Taylor was the trustee of the estate, while at the same time he had power of attorney over Margene's finances, and then later he became the personal representative of Margene's estate, and he's doing all these things kind of at the same time. He's wearing all these
Correct.
different hats and taking them on and taking them off. But I guess the question I have is how those facts lead to the legal conclusion the court drew.
They don't. They just don't, because we spent a lot of time in our briefing on this issue that no matter what, Margene Harding didn't have the power to enable him, and he didn't need it. He was the trustee of this trust. He was the sole trustee of this trust. Every distribution that he made out of this trust was made under the power of his sole trusteeship. She couldn't give him something that she didn't possess, and she didn't give him something that she didn't possess. And so the judge, the trial court, hung his hat entirely on this power of attorney.
Well, she benefited from some of the things he was doing, right?
Oh, absolutely, potentially. The thing is that if we had been alerted to an issue about liability, going into trial, if it had been pleaded, if there had been disclosures, if there had been discovery, obviously we would have prepared to address those issues at trial. And the question is, she was an elderly woman. She needed help to manage her finances. That's why he had a power of attorney to help her pay her bills. But that doesn't mean that she personally is the one who benefited from these excess distributions from the trust. Mr. Taylor is the one who the court found was benefiting from this because of all the different hats that he was wearing. But Margene Harding, if there had been a trial, we would have vigorously addressed the issue that she did not benefit from what Mr. Taylor did. In fact, as a beneficiary of the trust, she had every right to rely on him performing his duties, his fiduciary duties as trustee, just the same as the residual beneficiaries did.
What about the constructive trust theory? The court, I don't think it's fair to say the court rejected that theory. The court just didn't reach it, right? The court had this other theory it went down the path on, but didn't really say whether it thought the elements of constructive trust were met or not. Let's say hypothetically we were to agree with your position that these other two theories don't fly. What would we appropriately do with this constructive trust theory that's been raised? Is that a remand for the court to then consider this in the first instance, or what would we do with it?
Well, he didn't accept it, and he said that he wasn't using any equitable remedy in.
Well, he said he didn't need to. He didn't
Right.
say that he wasn't, that he
Okay.
wouldn't if he was in a different position, right? Those seem like different inquiries.
We would have to start this case all over again, because we would have to understand what the constructive trust theory was against our client, how much they claimed was subject to the constructive trust. We would
Yeah, because that's unclear to me, whether they would claim the entirety of the estate is subject to a constructive trust, or whether just Mr. Taylor's portion is subject to a constructive trust. I'm not clear on that.
Exactly, because it wasn't pleaded, it wasn't subject to discovery, it wasn't tried. There's no evidence on that. We didn't get any opportunity to present a defense.
Whether it was pleaded is a closer question. Maybe I'm not sure. I mean, the complaint is no model of clarity. It has a bunch of facts and no real causes of action, but it does ask in its prayer for relief, based on the facts pled, that some sort of constructive trust be applied, right? It doesn't use those terms, but
No, it doesn't use those terms. All it does is, in one clause, in one sentence in the prayer for relief, it says that she should have to repay something. And prayers for relief don't give notice. They don't impart
But on the other
notice.
hand, Rule 8 is a very liberal rule, and you don't have to plead legal theories. We just had a case that sort of said that. And so, it seems like they've got the better of the argument that it was pled. The question then is, all right, was it litigated? Was it tried? What do we do with it now, given that the judge didn't seem to reach it and the theory isn't on its face frivolous, right? So what do we do with it if we're in that position?
I don't know how you can do anything with it, because it wasn't part of this case. And if you were to interject a constructive trust theory at this point, First of all, it should be limited, as Harding himself suggested in his proposed findings of fact, to only a constructive trust against Rick Taylor's portion of the estate.
Yeah, I mean, those guys thought it was part of the trial. They put it in their proposed findings. Yeah, so, I guess you guys, I'm sure I'm gonna get a different story from him when he gets up. So, but should we just reject the theory? Should we reach the merits of it, even though nobody really briefed it? Should we remand it? I guess I don't know.
I dare you to find something in the transcript of this trial that in any way, shape, or form addressed the liability of the estate. It didn't happen. I think it has to be rejected entirely. It was a post hoc effort and limited in scope when they proposed this in their findings. The judge said, no, I'm not embracing that theory. So why should we do anything with it? I submit that the constructive trust theory is well, it would be completely unfair. It would be a violation of due process to interject that post-trial where we did not do anything to address it in the trial. Our only evidence, this isn't the kind of a case where you can say, oh, that the estate somehow acquiesced in this. The only evidence that we presented at trial was limited to the promissory note. We didn't acquiesce to a trial of something else.
All right, well, let's talk about the interest rate then while you're up.
Okay.
I don't know if you have some thoughts you just want to share. I have a couple of questions, but let me.
Well, it's a pretty straightforward proposition, I believe, which is the distinction between specifying an interest rate that later becomes difficult to ascertain and stating no interest rate at all. And, the only case that we could find that really hit the nail on the head was the Connecticut case where the bank, it was a particular bank's prime rate plus an additional amount of interest.
You said Connecticut, you mean Texas?
I thought it was.
I'm looking over at
It's
yours.
It's an Atlantic.
Looking over here.
It's an Atlantic.
Where's Les Slaw when you need him, right?
Exactly. But if you look at, it's at page 31, footnote 30 of our opening brief.
Okay, I see
It says 38 Connecticut app.
All right,
That's why I was thinking Connecticut. And so that case says, yeah, the bank is insolvent now. It's not there for us to find an interest rate. So it was incumbent upon the party asking for interest to present evidence as to what a reasonable rate of interest would be to substitute.
so let me ask you, nobody suggested this interpretation of the statute, but it sort of jumped off the page at me, and I'd like your thoughts on them. I'm talking about 70A-3-112. It says, if an instrument provides for interest, but the amount of interest payable cannot be ascertained from the description, then you go right to the judgment rate.
Right.
Is that saying that if we find that it's ambiguous, if we find that, look, we're going to look at the description, and if we can't tell from that what the interest is, then we go right to the default rate because this is the UCC and we want things to be streamlined in aid of sort of commercial resource hoarding. We don't want to waste resources arguing about some interest rate on something. We want to get there fast. And so is this one of those situations where ambiguity doesn't lead us to examining extrinsic evidence? Ambiguity leads us to, we're going to apply the judgment rate. What do you make of that?
Well, I submit that this is a case that's interesting because for many of the periods, there was an ascertainable interest rate. And so we were just filling in gaps.
Yeah, two of the gaps were like 4 years long, though. These are big gaps. These aren't
Well,
just like a week or two.
True. But and the reason for that was because they had a broker that they liked. He moved from one company to another, so they moved to the new company. And, but whether it's a big gap or a little gap, we were filling in gaps. We knew what the interest rate was for much of the time period that the interest accrued. I think it's really a public policy issue, and that's how we argued it in our briefs, which is that the parties are entitled to the benefit of the bargain that they made. The promissory note is a contract. It tells you what the interest rate was supposed to be. It was a margin loan rate of interest. And so what our expert did was he did his very best, and the judge said he had been very thorough in his approach and that he accepted his testimony. And so he tried to give effect to the intentions of the parties. They said, this is what the interest rate is going to be. It's going to be variable. It's going to be a margin loan rate of interest. And so he filled in those gaps. And so as a matter of public policy, we're submitting that the rationale of this Connecticut case is the better public policy because it gives effect to the intentions of the parties.
Okay.
Anything else? I know I'm past my time.
You're just fine.
Yeah, I have a question for everybody, and I'd like your thoughts on
Okay.
it before you sit down. And that is, are Jill and Gina parties to this case or not? And the answer to that question is going to, lots of things seem to turn on that. Like, assuming there is a judgment against Rick Taylor in favor of somebody, who's that judgment in favor of, and whose job is it to apportion between Robert, Jill, and Gina? You see what I'm saying? I'm confused about how this all is supposed to end up. There's just a judgment in favor of Robert for the entire shooting match. And did the judge expect Robert to then take care of his siblings in some sort of like delegated apportionment, or was there a mistake made, and should there have been in the judgment, some apportionment made between these three siblings in terms of who gets what's coming to them?
Well, I can only answer from my perspective, and I
I'd like
understand
everybody's perspective, yes. So I'd
But-
like yours.
the judgment is only in favor of Robert Harding. And I don't know how we just interject, and say, well, the judgment's also against other parties, in favor of whom the judge did not enter a judgment.
Well, but how can the judgment just be in favor of Robert Harding, right? Unless he's suing derivatively on behalf of the trust in some sort of, proxy form, right? It's the trust who had $5 million of damages, right? It isn't
Right.
Robert. So how did the judge arrive at the point where he issued a judgment in favor of just Robert for the whole thing?
I don't know. But let me say
What should we
this.
do about that?
I'll try to address that, Your Honor.
Okay.
We objected to the form of the judgment on the basis that it didn't address this issue that you've just raised. We objected to it on that basis. We briefed this. And the judge said, nope, I'm just entering judgment against Robert Harding. And so what is to be done about it now?
Which is interesting because at one point, the lawyer for Gina, who I think was Mr. Laird and Mr. Hinkins, right, at trial?
Yes.
At one point, they stood up and said, hey, I just want to clarify, my client's still a one-third beneficiary, is going to get one-third of this. And the judge says at one point, yes, that's right. Do you remember this?
I do.
And then it never really got memorialized that way in the documents, and I don't know why.
Well, here's what I would suggest is that, and I think Mr. Harding has some, whatever arrangement he has with his sisters. And they apparently feel comfortable with that. But if he didn't share the judgment with them, then I suppose that they would have a claim that hasn't yet been determined.
Is that the approach that you suggested when you objected to the form of the order? Or what did you say when you
We
objected to
thought
the
that the
form of the
court
order?
should address this issue because we didn't want to be subject to potential
I understand that,
uncertainty, yeah.
but how did you suggest the court address the issue? Where did you?
Well, I think that we suggested that the court should, because he was the only petitioner, that the court should say so. And, and if the court felt that, for whatever reasons, it should interject that issue, then it should deal with it in some fashion. But I think that our argument was based primarily on, we have a set of pleadings in this case. They govern this case. So,
All right, so what, if anything, do you think this court ought to do about that?
I don't know what this court might do about that. I think that we have to stick with the pleadings, what was tried. I just don't know that we can go back and engage in a revisionist process to interject things into this case that were never at issue.
So isn't it, let me just follow up quick then, isn't it really an issue of the amount of damages? I mean, there's no question that Robert is a beneficiary of the trust, but he's only a 1/3 beneficiary. And suing in his position that he did, he'd only be entitled to 1/3. So isn't the judgment really only valid for 1/3? And the sisters didn't file their own petition and pursue their own damages. And so if they wished to do so, they certainly could have, but they didn't. And so Robert pursued his claims, which were for 1/3.
I certainly think that's the case, and that's why we raised the issue before the judgment was entered, is because we didn't want to be in a situation where potentially the sisters might bring a separate action.
Right.
I think for the sake of allowing us to provide equal time and not get too off track on our timing for other cases, unless there are further questions from the panel.
Thank you. It's always
Thank
a
you.
pleasure.
Mr. Walker.
Thank you. It's a pleasure to argue here today. Let me address Judge Harris's question first. And I think Judge Oliver's comment is absolutely correct, that Mr. Harding could only pursue his claim, which was a 1/3 beneficial interest.
His claim didn't purport to be some sort of proxy or derivative claim on behalf of
It
the
did
trust,
not.
did it?
It did not. It was solely his claim. Now, that matter is further complicated by the promissory note. Promissory note was payable to the estate of Margene Harding. That note
Well,
is.
the interest was.
The interest only because of the settlement agreement that we'll talk about, the 2005 settlement agreement. But that promissory note was payable from two of the beneficiaries, essentially Jill and Robert, and not by Gina, who was not obligated to pay that. But I agree with Judge Oliver that your comment that Gina and Jill did not pursue their claims. And are probably time barred at this point from pursuing that.
What do you make of the court's comment that I referred to a minute ago, where he told Gina's lawyer, yeah, I barred you from making affirmative claims, but you're still in for 1/3 of this. You're still a petitioner, he said, for 1/3 of whatever the award is. What do you
Well,
make of that?
They weren't really petitioners. I think the court was ignoring the pleadings, as Mr. Lambert had argued, that they did not assert a claim and they were not in. And that claim was not litigated as part of the case. That illustrates again another point that we made in our brief, and that's of great concern to me. And one of the more obvious grounds for abuse of discretion by the trial court was that he did not allow Rick Taylor or our parties to bring their claim under statute of limitations. The settlement agreement was entered into in 2005. And the settlement agreement provided that Rick Taylor would no longer serve as trustee, but required the trustee to provide annual accountings of the amounts that were distributed. At Jill and Gina's insistence, Rick continued as trustee, and he did provide those annual reports. And this is beginning in 2005. So the claim is not filed until 2015, some 10 years after that settlement agreement, by Robert, essentially because of the garnishment, his ex-wife's garnishment of his interest in the estate.
Tell us why that ruling's an abuse of discretion.
Well-
Given that it was a year plus into the litigation before this motion to amend was made. Isn't
Well,
that something a court would have within its discretion to sort of manage its docket?
I think so, but again, the notice was given, there was inquiry notice that the parties had had the annual accountings of the distributions for 10 years and never raised a claim. And again, this goes to the point of Jill and Gina, never raised their claims, never brought claims.
But I think Judge Harris's question isn't so much whether the parties were on notice that the accountings had been produced for year after year, but rather why Mr. Taylor waited from asserting a statute of limitations claim a year into it, because that seems to be the basis of the trial court's ruling, is that you waited too long. You should have initially brought this, because it was certainly known to Mr. Taylor as well.
Well, I think Mr. Taylor joined in the objection of Robert Harding's ex-wife and in her pleadings, which asserted a claim for statute of limitations. So Mr. Taylor had piggybacked on those claims and gave notice to the parties. I think this also illustrates the challenge that we've got in a probate proceeding. It's a proceeding in equity, so you don't have the regular Rule 7 pleadings. You don't have a complaint, an answer, a counterclaim, a reply. So as a result of that, it was again delayed. But again, looking at the prejudice to the parties knew of all of these issues. That also goes to the question of the expert witnesses.
Well, on both of these questions, let me ask you a procedural question. I searched high and low for the transcripts of the oral arguments regarding the ruling the court made with regard to the motion to amend, and with regard to the ruling the court made to exclude Langdon Owen from testifying. And there's a lot of transcripts in this 14,000-page record, but I couldn't find those. Did I miss them? Or
No.
are they not there? And if they're not there, tell me why we don't apply the rule of regularity and hold that against you.
Well, I'm not sure, again, we came into the case after the fact, and I'm not sure why those transcripts are not there. But in ruling on the motions, again, Langdon Owen, and this goes to the court's initial comment, and that is that there was liability of $5 million imposed on Rick Taylor based on his supposed admissions, and that there were unlawful distributions. There was no analysis, there was no standard set forth, there was no expert that provided a standard, and there was no analysis of the evidence that supposedly Mr. Taylor had abused that discretion, that he had.
Well, I'll only push back a little about there was no standard set forth. I mean, the standard was there's a fiduciary duty to follow the trust terms. The trust terms expressly say no distributions of marital share principal, and there were undisputedly a number of distributions of marital share principal. Ergo, there was a breach of fiduciary duty. That seems like a pretty simple syllogism to follow. But the problem I have is that the order excluding Langdon Owen from testifying is one line. It gives no insight into the trial judge's ruling or reasons for making that ruling, which is why I went looking for the transcript, because I wanted to know what he was thinking. Presumably, he announced an oral ruling from the bench. We don't have the benefit of his thinking on this. And that seems like that's a problem for you.
Well, again, looking at the plain language of the trust, and I think the standard here, you have to look at the Uniform Probate Code. Title 75 talks about the duty of a fiduciary. You also look at the Uniform Prudent Investment Act. You also look at the plain language of the trust. And the plain language of the trust, basically paragraph 5.D3 of the trust says that related to the family trust provides that principal may be distributed in support and maintenance of her Margine's accustomed manner of living.
But not marital principal.
Well, it does. It says this is the family trust. So ultimately, that's where the money resides. The marital trust funds are used, and then the family trust funds, the principal in the family trust can be used to maintain her support. The paragraph 5 also states that in exercising these discretionary powers to invade principal, the trustee shall be mindful of the fact that the trustors, Harding's primary concern is establishing the trust is the trustee's spouse's welfare, and that the interests of others in the trust are subordinate to the trustor's spouse. So there needed to be an analysis of that in determining whether or not this was unlawful, and the record's totally void of any evidence that that was the case. And again, to find somebody breached their fiduciary duty without going into that evidence is improper. And again, abuse of discretion to find that Rick Taylor's liable now for $5 million without having any analysis at all regarding whether he was in bad faith, whether he abused his discretion. One of the main points to me, I think that's really significant again, is that Mr. Taylor did only what the trustees had done previously, that the prior trustee had done. The required minimum distributions were the same. From the IRA, the income was the same. So again, does a lay trustee, is he exercising his discretion to be able to do what the prior trustee did, and in following the advice of his counsel, of his CPA and his investment advisor? So,
But isn't reliance on experts an affirmative defense? I mean, it's something that he has to bear the burden of proving, because the facts as laid out show that the trust wasn't followed. And the position of Mr. Taylor really is, that's true with a but, right? But it was okay because
Right.
these experts told him it was okay. And that's where it's more of an affirmative defense.
well, again, you go back to the pleading issue in the probate cases where there's no, that was argued, it was asserted, it was claimed in the pleadings, certainly in response to the motion for summary judgment, that those experts, and again, this case is very complicated. The application of these rules is very complicated. I think Langdon Owen and Mary Ellen Siebold, who are our two experts, were crucial to the court's determination of these issues.
Your appeal regarding Siebold and the other one who's not named Owen, help me out. That appeal seems even more problematic since these guys selected report and there was no expert report. So isn't the court within his discretion to exclude those experts if you fail to provide the report that you're required to provide?
Well, it was Lynn Evans.
Lynn Evans, that's right,
Yes.
thank you.
No, I don't believe so. The reports that were prepared, petitioner prepared reports, and ours were rebuttal reports to
Well,
those.
right, and Ms. Siebold got to testify as a rebuttal witness, just not as a case-in-chief witness. So, I mean, it seems like the court went right down the line with what the court should have done on that one, no?
Well, I don't believe so. I mean, had Ms. Siebold been able to testify and give her complete report, there were significant issues there, such as,
But this was a disclosure issue with the expert. I mean, maybe we're getting ahead of ourselves, but this is a disclosure issue, that they were excluded for failing to comply with the rules.
yeah, but there was time for, there was no prejudice as a result of not disclosing the witnesses. Ms. Siebold testified, she signed a declaration in support of a motion to dismiss. It was disclosed, she was a witness, her testimony was considered. Her testimony was very significant in light of the ultimate issues in the case, and certainly on the question of damages. Her testimony was that there was about $703,000 of over distributions, but then the income, the net difference of the income was $1,388,000. Then the distributions from the marital trust, the difference that she calculated was $358,000. There was also her testimony that the income tax that the trust would have had to pay had it not been distributed to Margene's estate was $462,000. And that the remaining balance in there was $486,000. Those are significant numbers that again raise genuine issues of material fact. And that if the court had allowed, and to me, I'm sorry if I disagree with Judge Lennon, but the reality is I would have wanted as much information as I could on this case to understand the complex nature of these distributions, the complex nature of the tax laws and application of the trust. And Mr. Owen is a expert in this state regarding fiduciary duties. That, to me, as rebuttal reports, the court should have allowed those expert witnesses to testify to assist the court in making a determination in this case. But again, I'm probably out of time and appreciate it. Are there other questions?
Yeah, I've just a couple of more questions. These are sort of, with regard to a couple damages issues. You've raised an issue with regard to the damages related to the violation of the spendthrift provision, indicating that you think Robert wasn't damaged in the amount of $250,000 since he had a debt to Judith.
Yes.
It was extinguished.
Yes.
Can you elucidate on that argument just for a minute?
Well, again, it was a valid order of the court that awarded a garnishment to Judith, and we as fiduciary, the trustee, was obligated to honor that order of the court and to make that distribution to her.
Well, but I think the argument here is even that you're making in the brief is even assuming that that was an improper payment, Robert's damages aren't $250,000 from that payment.
Right.
Because he got something from that payment. He got a debt extinguished that equaled something. That's your argument, right?
Yes,
Okay.
that's exactly right.
And then with regard to the damages that to the marital home, I guess I need help understanding why Mr. Taylor ends up being liable for that rather than the estate, since the trust put the responsibility for maintaining the home on Margene while she was alive, and presumably on the estate after she wasn't, rather than on the well, I think I said that wrong. On Margene while she was alive and on her estate after she wasn't, rather than on the trustee.
I think
What do you make of that?
That's exactly the way we see it, that it was the estate was obligated to maintain it, not.
In fact, that's part of what the estate got sued for in Robert's petition, right?
Right,
So your position is that isn't Rick Taylor's responsibility, it was Margene's
that's
responsibility.
exactly right.
Okay, those are all the questions I have.
Any other questions?
No,
Thank you.
thank you. Appellees. I don't know that we're even going to set a clock. We'll see how this goes.
Very good. Jared Moss again for appellee Robert Harding. May it please the court, thank you. Just wanted to, I don't know if there's an order you want me to do, but I just wanted to address some of clarifications, if I may. First of all, the trial was not of just damages only. The trial was all issues not previously adjudicated, including liability as to the distributions from family trust, liability as to the estate of Margene Harding. And in addition to that was the expert witnesses on the amount of the actual damages, which was specifically reserved.
Well, point me to
in the
somewhere
summary
in the
judgment.
record where there was an indication that liability of the estate of Margene Harding was being tried.
What,
What, I
What
mean,
is the- what-
I realize the record is massive.
yeah,
I
so,
realize that's a
so
huge question.
the
but-
liability of the estate is.
During the trial, can you point to any point in the trial where somebody said, okay, let's talk about the liability of the estate of Margene Harding?
Oh, yeah, I mean, that was specifically addressed throughout the entire litigation. The estate was brought in from the very outset, number one.
Yes,
As it-
but for the house,
No, for the return of the wrongful distributions. Again, where did the distributions go? The distributions flowed,
okay, so
To
you're
the estate
referring
of
now,
Margene
you're
Harding.
referring now to the line in the prayer for relief in
not only
in-
the prayer, but also the several provisions of the petition state In fact, petitioner believes and understands, and from the information, so let me give a little background. First of all, there was no accounting provided to Robert Harding. Robert Harding, it was admitted by all parties, Robert Harding was in the dark as to this trust. Never received accountings, did not know any information as to the details of what happened in this trust for 10 years. No information. So when we received the final accounting, when Margene Harding passed away, for the first time ever, Robert Harding has a starting balance and an ending balance, and a missing record of 10 years. And we have a balance of over $5 million when the trust was created, and a balance of less than $2 million. Where did the money go? That was the premise of the outset of this case. And so what we did know from the start of the petition was the recipient of all funds was Margene Harding and her estate. That was known. And so the whole premise of this is, how do we get money back? One is breach of duty by the trustee, Rick Taylor, as not only the trustee for the trust, but also as a personal representative and power of attorney for Margene Harding at all times for a 10-year period. So we know he's the one acting, making the distributions, we know that. And more importantly, we know where did the funds go, went to his mother. So those are the facts we know, that's what's pled, and that's what's asked for from the court. We need relief. We need these funds returned from the wrongful parties. Rick Taylor as the trustee, and number two, from Margene Harding as the recipient. That's what was pled, and that's what was asked for.
And that
so
was
that
only,
is the liability.
and that was only pled on behalf of Robert Harding though, right? The two
Correct.
sisters are not parties to this
So
petition,
That's
and
right.
Robert was not attempting to represent their interests as
Well-
beneficiaries.
he's representing his interest at
Right.
the outset. Early on in the case, Jill and Gina were at a certain point adverse to him for a moment of time. They were friendly with Rick Taylor, and they took his side. at the
But they don't
early
have
start of the
affirmative
case.
claims, and Robert's not making claims on their behalf.
Well, he's making claims on the behalf of the return of all the money that was wrongfully distributed.
But he can only do that on behalf of his sisters, right? Because
Right,
he
and he-
only has a claim of a third.
Right, but again, the pleading of this is also not on Robert Harding, but for the trust, marital and family trust of the Dean Harding Trust. And it also asks for removal of Ricky Taylor as trustee, which what eventually happens in this case.
So,
So now I'm confused. I will say because
too.
Okay,
Yeah.
because I want to understand. So your position then is that Robert sued as the petitioner here,
Petitioner,
and he, although only having a claim as a 1/3 beneficiary, is suing on behalf of all of the beneficiaries
Yes.
to get all of the money back.
yes, and that would.
And so
but
yeah, how does he do that? Where
So-
does it show
so-
that he's doing that? Where does he have the standing to do that? And how do we reconcile that with the district court telling the sisters that they can't make affirmative claims?
well,
So as a
and
beneficiary
let me
of the trust,
add on to
yeah,
that question
yeah.
so you can answer it all at once. How do we reconcile that with the face of the petition,
Yeah.
which lists his sisters as adverse parties,
Not as adverse as interested parties. So again,
as respondents?
as respondents.
So
Uniform
they're not
Trust Code-
they're not co-petitioners,
They're
they're
not co-petitioners.
respondents, but you're standing here saying that was filed on their behalf.
Not filed on their behalf, on behalf of getting all of the money back into the trust. Again.
Right, but Robert doesn't have standing to get all the money back. He
Sure
can
he
only
does.
get a third,
He's a beneficiary of the trust.
but he's only a third beneficiary.
Yes, but you can get it back for the benefit of the trust, and that's what happens, right? And so and eventually Robert Harding becomes co-trustee of this trust, standing in the shoes for everyone. In this case, this is what happens through the lineage of and the history of this case.
So take us to the end of the case.
The trial court.
The judgment's only in the name of, in
Robert
favor of
Harding.
Robert Harding,
Robert
and not
Harding.
Robert Harding on behalf of the beneficiaries of the trust, not Robert Harding as a 1/3 beneficiary, just Robert Harding gets the $5 million.
Right.
So it's just out of the kindness of his heart that he's gonna share it with his sisters, and if he decides not to, then more litigation ensues?
But he's co-trustee of the trust now. And so now,
But is he recovering as co-trustee?
yes, yes.
So the judgment's in his name as
his name.
co-trustee.
As the interested party.
It's
at
just
time
in
of
his
petition.
name.
It's in his name.
It's not, it doesn't say co-trustee.
No.
It doesn't say in his capacity as co-trustee. It doesn't say in his capacity as anything other than his name. So when he goes to collect this, he has a judgment that says, Robert Harding, I get $5 million.
You're correct.
I can tell his sisters to pound sand, right, and make them sue him. They have no right in that judgment,
If,
as it's written, right?
as it's written, you're correct.
Okay.
You are correct. Now, should have the court maybe amended that? Should have the court said, okay, who is the real interested parties here under
Well, you-
procedural rule?
You resisted their motion to make that precise amendment, right?
Right.
Why?
Right. It.
Now you're standing here saying that's
he's-
what the
he's
judgment
standing- He's
says.
standing in the shoes of the trust. He's a co-trustee of the trust. He has a-
Okay, but-
He has a
But
fiduciary
it doesn't
duty
say
to
that.
If that's true, why oppose their motion?
It's unnecessary, right? It's unnecessary to have to go through this whole procedure of unwinding what Robert Harding has done on his behalf. He's the one that's incurred all of this cost for the benefit of everyone.
Seems like the only reason you would oppose that motion is if you wanted to retain leverage over the sisters.
I don't think
And
that's.
I don't want, I mean,
I don't
you don't
think
have to
that's the
answer
case.
that, whatever, but it seems,
But
sitting here now,
again,
that seems like.
remember how this case started. The sisters were not in Robert Harding's camp at the outset. Okay? They actually filed declarations on behalf of Rick Taylor at the early phases of this case.
Which is why I'm saying the original petition could not have been on their behalf. Okay, so,
But regardless, throughout the case, how it progressed throughout the case, they eventually became favorable. They eventually sided with Robert Harding. And the court recognized that as well, and it was done at trial. That's what was tried. At trial, we are here on behalf of returning all of the funds wrongfully distributed that the trustee should not have done under the stating, the plain terms of the trust. So, and that's what was tried.
can we go back to the estate's liability question, which is where you stood up and started? So you've argued that the liability of the estate was tried, all right.
Yes.
What is the legal theory for that liability?
Yes, and the court got it right in this position. The court says, not very eloquently, but in its ruling, it says, both in the 77 ruling, findings and order, but also subsequent order on this issue was, there is terms of contract here, breach of contract. And there's two contracts. One being the terms of the trust.
But the estate's
The
not a
estate-
party to the trust contract.
Sure it is. It's a
The
beneficiary.
estate of Margie and Harding is a party to the
Margene
trust?
Harding individually is named in the trust agreement.
Okay,
Right? And therefore, her estate stands in the shoes of her individually. So the estate has that claim. It had the benefit. So that's how it's
so
liable.
she's the beneficiary of the trust,
Of the trust.
therefore she can be liable for breaching the trust?
For breaching the trust. You're only allowed what you're allowed. She received
So
funds
it's-
she was not entitled to. Therefore, she's in breach of the terms of the trust.
That,
So that's one. The second one is under the
but what did
contract.
she do to
Right.
breach it?
She received and did not return funds that were wrongfully distributed to her.
Right, so it wasn't an affirmative act by her because the state argues that Margene never had the ability to distribute the funds to herself.
It doesn't
Right.
matter if she has the ability to or not. You're receiving funds as a beneficiary.
Oh, I can see a claim for something like constructive trust or fraudulent transfer, but breach of contract.
Or maybe even
I'm
unjust
having a hard
enrichment.
time with that.
But,
The contract terms are what they are. As a beneficiary, I'm only entitled to receive what I'm entitled to receive. If I'm not entitled to receive it, that needs to be returned. You are in breach of the terms of the agreement.
Okay,
That's
what's
the-
your other legal theory?
That is what the court ruled. Right?
I know,
Second one is under power of attorney. As the power of attorney is the agent liability, principal and agent liability. She is liable as the principal for her agent's actions of not
so
returning.
explain to me how Rick Taylor was taking those actions, and by those actions, I mean improper distributions of principal out of the trust. Explain to me how Taylor was taking those actions with his power of attorney hat on. rather than his trustee hat on.
So under power of attorney, what he testified to was Margene Harding directed me to get this money. That's what he testified to.
Okay, but
So under
Margene
power of
Harding
attorney,
doesn't
he's
have
now
any.
standing in her shoes.
Right,
She
so-
has no authority to direct him to do that under the terms of the trust, right? The power of attorney, isn't it, just limited to control over money once it hits Margene's account, right? Once he as trustee puts the money in Margene's account, then he can use his power of attorney to distribute it, to write checks however he wants to. But the authority to get the money into Margene's account, I'm struggling to see how that has anything to do with his authority as power of attorney. Can you help me there?
Under power of attorney, then his duty now at that point is to return the funds. That's what he should have done.
As power of attorney?
Right. He had no duty to keep that money that she had no right to. So he's breaching that power of attorney in the sense that she's only entitled to,
So this goes back to the
That
breach of
goes-
This is the
contract.
same, yeah, this is the same breach of contract
Same
theory.
breach of
What-
contract theory, it's just, instead of Margene who has the obligation, it's Margene's power of attorney who has the obligation. These seem like the same theory.
they're a little bit different, but in my eyes, but.
Well,
get
I
where-
mean, as power of attorney, he's acting for and on behalf of Margene. He is Margene for the purpose of that, right? So seems, I don't know.
And for purposes of that, she has the requirement or the obligation to return funds wrongfully distributed.
And as you argue, that obligation is under the trust.
I mean, the other breach of power of attorney is what was argued today and throughout the brief was, it was for her benefit. And what we found and what the court ruled on was, in fact, none of these funds, or very little of these funds, was actually for Margene's benefit. Like, they actually went to the personal benefit of Rick Taylor. So you could also, the court was looking at it there saying, Rick Taylor was breaching both his contractual duty under the terms of the trust agreement and his power of attorney obligation to, for her benefit, no, he was using this for his personal piggy bank.
And if that's true, doesn't that weaken your argument that his power of attorney leads to estate liability if he's using the power of attorney for his own benefit?
Well, I think it goes to, that's why the estate is liable, is that's where the funds should have gone. And he took them out.
Well, the funds never should have gone anywhere, right? They should have stayed in the
That
trust.
was our argument. Yes, exactly right. They should have stayed. They should
And the
have
fact
grown.
that they left the trust is a trustee issue, not a power of attorney issue.
Well, I think it's a breach of power of attorney because you're breaching that duty. You're not doing it for the benefit of the principal, you're doing it for your own personal
Right, but
gain.
help me how you have standing to raise that issue within the trust, because essentially what you're saying is that I understand there's the first argument that the distribution never should have been made, but you're making a second argument that once the distribution is there, Rick Taylor violated his duties as the power of attorney or the trustee of the Margene Harding Trust because he used the money for his own benefit, which violated the terms of that trust. But Robert Harding isn't a party to that trust. He's not a beneficiary, right?
No, but under the Uniform Trust Code, the rights there are recover of funds. So once a breach has been proven, which the court found, and when
So it doesn't matter really where they
the court
went.
can then go into where are these funds and reclaim those. And that's under
Right, but that's not
Uniform
that's
Trust
not
Code.
an issue of breach. That's just a matter of recovering from the correct party.
That's right, and that's where we believe that standing lies, is through that trust code, is saying, yes, you're bringing that request for an order of return of funds.
Right, so,
against those
so just
parties.
following this through, and I think this is an argument the trust, the estate makes, is if the money flowed through the estate to Rick Taylor, right, then how is the estate on the hook for that joint and severally if Rick Taylor wrongfully took it from the estate? Because what you're saying is you have standing to get the money back, right? And so you're just following the flow of the funds. Well, if the money went to Rick Taylor, then the claim is against Rick Taylor, not against the estate. But you have a judgment that's joint and several. So how is that correct?
I think it's correct in the sense that the estate had funds that could have paid for these wrongful distributions. And our point is that, and the trust code allows for this as well, not only for recovery of the funds, direct, right, tracing the funds, but also for recovery of any amount to repay that was wrongfully taken.
Let me ask you.
So whether we get it from Rick Taylor or the estate, that's where the court's right. We don't care where the money comes from. That's why you're joint severally liable. You've got to return these funds.
With the constructive trust theory, it seems like that makes some intuitive sense, right? Rather than these breach of contract theories that I'm having a hard time lining up, the constructive trust theory, it just says the money ended up here wrongfully. We want to trace it. We want to claim it. We want to bring it back. Assuming we get to a constructive trust theory, same question I asked to Mr. Lambert, what do we do with that theory here? Because the court seemed to jump over it, right? The court seemed to say, well, I don't need to reach the merits of the constructive trust theory because I've got these other theories that I think work better. And so the court never engaged in sort of the element by element analysis against whatever evidence had been presented and never really engaged with that theory. So if we get down to that point in the flow chart here, what do we do? Do we remand? Do we try to do it ourselves? Do we?
I think this is an interesting component, and this is, trust law and probate law are interesting animals in the sense that they're both law and equity. And I think the court here, and I think Judge Lennon did the best of his ability. I think he got it right. But let's say we go down the constructive trust path. I think that this court, or even at remand at trial court, the court can easily go to equity. The court in its ruling said, I'm not going there, but I think that's the proper analysis. And I think this court could do it just as eloquently and say, here we have equity. We have sufficient findings of fact. We have sufficient admissions. Principal was distributed, shouldn't have been. Family trust was breached. I mean, we have enough findings here. What is the right ruling? Is it constructive trust? Is it equity? Is it some unjust enrichment? And I think we can get there. What is undisputed is this judge did a great job at getting the right result. And as far as the money needs to be returned, it was wrongfully taken. It was admitted to that fact. And we had expert witnesses. The other side had an opportunity to provide expert reports. They didn't do so. This court did a great job of managing its calendar and docket, following the court rules on excluding those experts.
Am I right that we don't have transcripts of the motion to amend hearing and the expert witness hearing?
We do not. You're correct, Your Honor. And I think the court is correct in its questions and its concerns. And I think it is unfavorable for the appellants that those are unavailable. And
What about
Judge
these?
Lennon's ruling should stand and be upheld
What
on
about
those
these
issues.
These two damages issues I asked Mr. Walker about at the very end? The $250,000 line item in your damages. What do you make of their argument that Robert Harding wasn't damaged $250,000 from that payment? He may have been damaged $35,000 because that was the amount that was taken from, I guess, his house, or he may have been able to make out some sort of claim that I could have negotiated this down with Judith to 200 or something. But why are his damages $250? Why does he get the whole thing?
Yeah, I think you're right in the sense that because what the court said there was, one, the spendthrift provision, two, was the duty to defend. The trust and the trustee had a duty to defend this claim. Didn't do so. And because of that, that's the damage. Robert Harding could have either defended it 100% and said this amount was not owed. Wasn't given that opportunity. That's why the full amount should be awarded. And that amount actually was paid
Well, didn't Robert admit that?
in violation of the
Didn't
spendthrift
Robert
clause.
admit at trial that this did extinguish a debt he owed Judith? It was just some question about what the amount was?
That's right.
And so didn't the district court need to engage with that and figure out what the actual amount was and deduct that from the 250 to get Robert's actual damages from this payment?
Problem is we can't know that, what those damages could have been. I mean, it's speculative at that point in the sense that don't know how
But isn't this
successful Robert Harding could have been in that defense.
Isn't it a double recovery at some level? Unless he could come up with a zero owed to Judith, any payment he's getting a double recovery of then.
I don't see it as a double recovery. I see it as an amount that he didn't have to pay.
So let's say, so 250,000 was paid, there's no dispute about that.
Yeah.
So let's say, as Judge Harris said, he could have negotiated it down to 200,000. Well, he not only got the benefit of the $200,000 being paid, he got 250 on top of it. So he comes out ahead, way ahead, right? So why does he get to come out so far ahead?
I mean, one is it's an express violation of the Spendthrift Trust. And number two is, I don't see it as a double counting or some windfall. He's getting money back that he shouldn't have ever had to spend.
But he didn't spend it. It was paid on his behalf.
In effect, it's still his spend. It reduced the amount that he could have recovered from the trust as a distribution.
Right, but it also
And-
extinguished a debt that he otherwise owed in an amount that he disputes, but it did extinguish a debt. I mean, there's no dispute
did.
there.
Yes, it did.
Tell me your
But
theory.
but it went to something that, I mean, he could have used the money for something else. Instead, it went to paying a debt, and he never had the chance to dispute that, to defend that, to contradict that.
Can you help me understand your theory as to why Mr. Taylor is responsible for whatever damage happened to the marital home rather than the estate? I mean,
Yes, it was,
And where I'm coming from on that is, as I
Yes.
read the trust document, it looks like it does put the responsibility on Margene during her lifetime to do those maintenance obligations,
so again,
not the trustee.
you're right in the sense of how the trust agreement reads. And again, during this time period, Rick Taylor was the one acting on Margene's behalf. And so in that regard, it was his responsibility, both as power of attorney and and acting on her behalf, to maintain the home.
We know,
And
do
what the
we know,
testimony that was provided was that he was the one that failed.
how do we know
To
that the
maintain
power
the
of
home.
attorney put that responsibility on him? My understanding is the power of attorney was never actually entered into evidence. We don't know what it says.
We don't have the record of that power of attorney, you're correct.
And generally, without knowing more about what this one said, power of attorney is just generally, power to, sign checks and withdraw money from their bank account and pay bills and make sure that things get paid.
I would say yes if it's a limited financial attorney, power of attorney. There are broader power of attorneys, which are durable power of attorneys, which are under statute. And those provide rights and responsibilities that go beyond just financial responsibilities. And Mr. Taylor never disputed that it wasn't his responsibility to take care of the home. In fact, that's what the evidence was, is all of his failures to maintain the home,
His failures.
his failures,
Not hers.
not hers. What was testified to, she had full-time residential care. She couldn't take care of the home. She couldn't buy groceries. She couldn't
Right,
write
but
checks.
it's her ultimate responsibility to do so under the trust, and just because she delegates that responsibility to somebody else, it seems like there's a problem with the trust, and it's ultimately hers, right? She's the principal here in this principal-agent relationship, no?
Yes, but what was testified to and what the court found was it was Rick Taylor who took upon himself this responsibility.
Okay.
He testified to that. But what he was pushing for was, I am here to take care of my mother. That's all I'm doing. Everything I'm doing is for the benefit of my mother. And what was proven and what was shown was that no, he allowed her to live in squander. Did not take care of the home. I mean, lived with infestation. It was a disgusting home, unfortunately. That's why the court found it his responsibility, his liability. Did not even take care of his own mother. even though that's what he was professing to be doing for 10 years while he was unlawfully taking money. So in the sense that, did the court get it right? Yes. This court even indicated at one point this was to the borderline of criminal conduct by Mr. Taylor.
I think we've allotted a roughly equal time. I've been watching this clock rather than
Great.
this one.
Thank you.
Thank you. We'll put 5 minutes on for rebuttal because you reserved it. And
Are you intending to speak, Mr. Bergman, in this case, or are you waiting for the next one?
I actually will be arguing the next one, Your Honor, but if there are any questions, I'm happy to answer them. But,
Do you have thoughts about whether your client is a party to this case?
I do, if you want me to address that very
I
briefly.
think a couple of minutes of thoughts from you would be beneficial to help us understand this party problem. Like, your client's the one interested in standing here arguing that a third of this money is hers. What's your position?
Let me try to address that. And it is very convoluted how we get to it, but it does work. Both Jill and Gina were parties to this case. They were named as respondents, not because they were necessarily adverse to Robert, even though they were initially more supportive of Mr. Taylor than they were of Mr. Harding, but because as parties with an interest, they had to be named as a party so that all of the interests related to the A. Dean Harding Marital and Family Trust could be adjudicated at one time. And so they were brought in as parties in that case. Over the course of the case, they obviously became aligned in interest with Mr. Harding. At trial, I sat at the table with Mr. Harding's counsel and essentially prosecuted the case on behalf of Mr. Harding and Ms. Kendall, not as a respondent. And so the other thing that happened, as Mr. Moss pointed out, over the course of trial, there was a motion to remove, over the course of the case, there was a motion to remove Mr. Taylor as trustee. He was removed. Bob Harding and Jill Kendall were appointed co-trustees of the trust. And even though the case was originally brought by Mr. Harding in his name, he was really seeking, he didn't say he was seeking on behalf of the trust, but that's ultimately what he was doing, is seeking that the trust money be returned, that the improper distributions that Mr. Taylor made from the trust to Martin be returned.
And I get that. I get that that's sort of what's going on, but it seems like if that's what's going on, then one of two things need to happen. Then the judgment needs to be Robert Harding in his capacity as acting on behalf of the trust, so then the money goes to the trust and then goes out to the beneficiaries. Or the judgment needs to be amended to put all three beneficiaries on there so that they get the money in the first instance.
I don't necessarily disagree. I think that the most appropriate thing would have been for the judgment to be on behalf of the trust, because at that point, Mr. Harding was one of the co-trustees. And that would be the most, both the correct way and the most efficient way to then ensure all the beneficiaries' interests are properly adjudicated, because once the money goes back to the trust, the co-trustees then distribute the money to the beneficiaries according to the trust. The fact that it ended up just being in his name because he was the original petitioner, is consistent with how the pleadings read. I don't think it deprives Ms. Kendall or Ms. Vucinic of any rights in this case, because their rights were being adjudicated as well. And the ultimate ruling of the court is that the money had to be returned to the trust, even though the final judgment was in the name of Robert Harding. Any amounts he does recover would be for the trust and then get distributed to all three beneficiaries. So
Where does it say that, though, in the documents?
It doesn't, other than the fact that he was appointed one of the trustees during the course of the case.
And what's your argument going to be on behalf of your client if Mr. Harding absconds with the money next year? Are we going to be back here in case 3, in litigation number 3 involving these parties? When
I certainly hope not, and that has not been the case so far. As you know, the next case is
But-
that we'll be arguing is also on behalf of the trust, and it's Ms. Kendall and Mr. Harding as co-trustees pursuing that.
I
But
get
you would
that.
agree with the judgment as it's written, Mr. Harding certainly can't keep all those funds. Now, it would be subject to litigation and future claims, but he certainly could take that order and all
On its
those funds
face-
go to him.
On its face, that is an argument that could be made. I think that because he was appointed a co-trustee before this judgment was entered, that would actually limit his ability to make that argument, but on its face, one could read it that way, yes. That's why I say,
But-
all
but-
things being equal, it probably would be better to be amended so that the judgment is in
You're-
favor of the trust.
Your client's a co-trustee now too, and so if the intent was to make the judgment in favor of the co-trustees acting on behalf of the trust, you would think that the judgment would reflect that, and it doesn't.
It doesn't, because it was Mr. Harding who brought the original case, and so to maintain the way the pleadings were originally brought, that's why the judgment reads the way it
Yeah, if
does.
we're gonna go by what's in his original pleading, he sued your client as a respondent, so the money's his. So there's just this disconnect with what was originally filed with how things ended up, and nobody ever sort of linked it up. And I guess I wonder what you think we ought to do with that judgment now. Should we remand it? Should we try and fix it ourselves? Or what should we, or should we just cut it and, like what he wants us to do, is cut it by 2/3 and give Mr. Harding 1/3 of the money and your client 0?
Yeah, I definitely don't think it should be the latter. I think that one of two things would be the appropriate thing. One, this court could, for lack of a better term, reform the judgment to make it in the name of the trust, which I think would be a correct thing to do. Alternatively, it could remand it to the district court to do just that, and that is reform the judgment so that's in the name of the trust, which is how it's being treated by Mr. Harding, Ms. Kendall, and Ms. Vucinic in the first place. But that would also be consistent with what was being done here, because this was ultimately a petition to determine the rights of all the parties related to the trust.
Right, but isn't I don't think that's how the petition was filed. The petition was filed against Mr. Taylor primarily, right, to get back the money that Mr. Harding claimed should have been kept in the trust and not distributed. Right, so it wasn't that this was a case against the trust, it was a case against Mr. Taylor.
Well, the original pleading was against Mr. Taylor in his capacity as trustee of the trust. The trust was named as one of the respondents. Jill Kendall was named as a respondent, Gina Vucinic was
Right,
named
but
as
you're
a
flipping
respondent.
it around now to say that really this whole case is for the trustees, right? The trustees brought this case.
Well, no, it was originally brought by a beneficiary because of the breaches by the then trustee. Over the course of the case, the trustee was
Right, so
removed.
where are and this is I think the trick we have, where does that show up anywhere? Where do we have amended pleadings, right? Where do we have an amended petition?
Is the judgment in favor of a beneficiary, or is the judgment in favor of a co-trustee?
Right, and I understand the question, I understand the concerns you have. There is the order, I believe I want to say November 2017, long before trial, removing Mr. Taylor as trustee, appointing Bob Harding and Jill Kendall as the co-trustees. And at that point, it may have made some sense to amend the pleadings. They weren't, or to reform the pleadings under, use, for example, a Rule 15 supplemental pleading or something like that.
Yeah.
That wasn't done. I think that could be done so that it reflects what really ultimately happened, because ultimately this case was about determining everybody's rights and interests underneath the trust.
When
So-
the estate raised this issue post-trial and asked to amend the judgment to fix some of this stuff, and Robert opposed it, did your client take a position? I can't remember.
I don't believe we did, because the reason their motion we believe that the purpose of their motion was to do to essentially cut the judgment down by 2/3. And so that's why we were not in favor of what they were doing. And so if we did anything, I filed a supporting motion with Mr. Harding in terms of leave it as it is. Because as it is, with Mr. Harding being appointed as one of the co-trustees, we believe that it was ultimately a recovery for the trust.
Okay, thank you for jumping up on the spot, Mr.
Little ad
President.
hoc
My
argument.
pleasure, thank you.
Yes.
We routinely limit the evidence in a case based on disclosures. In fact, sometimes harshly so. And you don't need to look any further for an example of that than this case, because the evidence in this case that Mr. Taylor could present was limited by failure of disclosure.
You're
And
talking about the experts?
yes. And yet we're supposed, even though there's no cause of action or elements of a cause of action alleged in the pleadings, there's no disclosures of any kind pertaining to a constructive trust theory or an unjust enrichment theory in this case. And even though the court said, this is what we're going to try, these are the issues. And then Mr. Harding tried to bifurcate this and say, the estate doesn't even need to be part of this trial. And so somehow we're just supposed to ignore all of that when we routinely limit the evidence based on non-disclosure. There was no disclosure by Harding in this case of any claim against the estate. And the court, Judge Harris, said, are we going to engage in an element-by-element analysis of these other causes of action? Well, that's exactly what we've briefed. And one of our points in our brief is we were entitled to an understanding of what the claim was, to go element by element, to look at the evidence, to see, what our defenses would be. And if Mr. Taylor was the one who used this as his own personal piggy bank, as they said, then he's the one, not the estate, should be responsible for that. And we would have had an opportunity to separate those things out. We never got it. And so we submit that the joint and several liability judgment just has to be vacated. It cannot stand. There is no valid legal basis upon which it would stand, and the ends do not justify the means. We have rules of procedure that have to be followed to provide due process and fairness. And so just because, as Mr. Moss said, Mr. Taylor was bad, and we can get there from here if we remand this. This case shouldn't be tried again. The liability of the estate was not established and should be vacated. Thank you.
Thank you. Thanks to all of you. We'll take the matter under advisement.